Our next story is an interesting one and a bitter one. A high-profile divorce involving an heiress of the McCain Foods empire and a former CEO of the Toronto Symphony Orchestra has been heating up in court for the last several weeks, with Eleanor McCain saying her ex-husband Jeff Melanson should not receive the $5 million agreed to in a contract before they got married. The couple stayed married for less than a year, and the divorce has been very acrimonious. So for more on this, we're joined by Catherine Robinson. She's a family lawyer at Shulman Law Firm in Toronto. Thanks for joining us, Catherine.
Good morning, Christine.
So this is an interesting case and a bitter case, and I want to try to stay away from the sensational aspects of it because I think it's easy when we're talking about semi-celebrities to focus on the gory details of this kind of thing. But from a legal perspective, watching this case, do you think Ms. McCain has grounds for an annulment here?
Well, an annulment itself is very difficult. It's a very rare type of instrument that's used in terms of dissolving a marriage. Obviously, the vast majority is going to be through divorce. So annulment does require specific grounds, whether that's going to be misrepresentation or fraud before the marriage is happening at the very beginning, or some type of lack of capacity. So if someone's too young or mentally unfit in order to enter into that marriage itself. So it does require those specific circumstances. Obviously, I've not read the court documents. I'm not involved with the case, so it's hard to say whether she does have the evidence that would support one of those grounds. If anything, it would likely be in the fraud category based on the information that's available through the news. But it's impossible to say whether that would be enough to merit an annulment actually being granted.
Well, it's interesting you talk about fraud or misrepresentation, and one of the accusations when Eleanor McCain filed for the annulment back in March was that her ex-husband, quote-unquote, tricked her into marrying him. But they did have a marriage contract that they signed before they got married, which correct me if I'm wrong, but as I understand it, is kind of the Canadian equivalent of a prenup. Is that right?
Yep, that's exactly right.
Okay, so is the annulment void because of the existence of a marriage contract? How does that change things?
I wouldn't think it would have any effect on it because the marriage contract goes towards the other issues, not the marriage itself. So the annulment would be talking to lack of capacity or lack of information going into the marriage itself. But if you look at immigration grounds, because oftentimes you get people who are looking for admittance into Canada, and there's trickery on that basis sometimes, that doesn't even ground an annulment.
And the marriage contract, assuming both couple is entering to it with their eyes wide open, that does tend to be a legally binding document unless, as you say, you can prove that there were some extenuating circumstances, right?
Yeah, basically a marriage contract is going to stand unless either party is going to claim that it needs to be set aside, and that itself is another test that would have to be met. So that could be through lack of financial disclosure, that could be lack of legal advice. So there are certain ways where you can challenge a marriage agreement, but again, that doesn't mean that it's going to happen.
Mm-hmm. So that's interesting because in the filing made last week, Eleanor McCain, says that basically her ex-husband, Jeff Melanson, has disqualified himself from the marriage contract, which included $5 million that would go to him because of the misrepresentations that he made. And so I don't know the details of what she is accusing him of saying or how he's allegedly misled her, but it sounds like that is the case she's trying to make. So if she is successful in making that case in court, is she then eligible for an immediate divorce?
No. So a divorce can only be granted on one of three grounds. The most common ground is to live separate and apart after a year. The other two grounds are cruelty and adultery, which would allow the divorce to be granted immediately. But those are both more difficult because you require that external evidence, cruelty more so than adultery. But the normal circumstances, living separate and apart for a year, still requires that 1-year waiting period, and divorce wouldn't be able to be granted immediately.
And it sounds like this is something that they would like to get done as quickly as possible. So
it certainly does.
It's an interesting case because they weren't actually married for that long. As I mentioned, it was less than a year that they were married. So in your experience, what would Mr. Melanson be entitled to from her estate with the breakup occurring so early in their union?
Well, that's where the marriage contract more so comes into play, because the marriage contract is going to be what they've decided in advance of the marriage is going to govern the property split and potentially other issues on separation. So it's likely that that marriage contract is going to have a full set of circumstances that if they separate at a certain period of time, or in general, that he would be entitled or she would be entitled to certain things. So it seems to indicate that he would get that $5 million payment if they separate. So that's something that would cover the property division most likely. Without the marriage contract in place, so if she does try and challenge it on the basis of fraud or misrepresentation or anything in that realm, then the normal property splitting rules would apply if the agreement is set aside. And that would mean that there would potentially be equalization, but because their marriage is so short, there is the possibility of not having equalization or not having it to the extent that you would after a long-term relationship.
Well, that's interesting, because I was going to ask, could having the marriage contract voided actually backfire, assuming that her property is worth more than $10 million, right? So if you have to split it 50-50, but you think that given the shortness of the marriage, that might not result in a 50-50 split?
Yeah, very, very easily could not. Also looking at the fact that equalization is looking at the increase in value from date of marriage to date of separation. Mm-hmm. So anything that she did come into the relationship with is going to be excluded property because it's your date of marriage deduction.
Okay, that's interesting. So this is a high-profile case, and it's not surprising because we're talking about a member of a very famous Canadian family. The McCain Foods empire is very well known to any Canadian who buys deli meat or hot dogs, for example. And then the former CEO of the Toronto Symphony Orchestra. So two semi-celebrities here in Canada, arguably. And we're talking about a lot of money at stake as well. So, you know, in your practice, if you're advising individuals who perhaps are looking at getting married and considering a pre-marriage contract, especially wealthy individuals, what advice would you give them to ensure that this kind of nasty fight doesn't happen?
Well, whether you have a marriage contract or not isn't necessarily going to stop the nastiness or the acrimonious nature of the divorce or the claim for annulment. So really, when you're going into consideration of a marriage contract, you just want to make sure that you're well informed, of the other person's finances and situation, and you have all of that information before you signing a document that is a binding document in the absence of a claim to try and set it aside.
Do you think the wealthy need to be more careful in planning out this kind of thing, more ruthless perhaps in enforcing pre-marriage contracts, or is this something that could happen to anybody?
It could happen to anyone, but the consequences are greater when you're dealing with larger asset bases, because then obviously if something goes wrong, then there's a greater financial impact. But there's the potential that a marriage contract would be helpful for a number of different situations and individuals, because oftentimes you'll see people who have pre-existing assets that, for example, the family home that they want to protect, what would be the matrimonial home, or if people who have children from previous relationships. So there are different circumstances where it becomes a priority over not, but the general property sharing rules in Ontario are such that you're only going to share in the increase during the period of the marriage, with some exceptions.
So the marriage contract, which again is a Canadian version of a prenup, which is probably the term we hear more often through American media, but is that something that you would recommend anybody consider at least before they get married?
It's probably worth a consideration, but again, if depending on age, depending on financial circumstances, some people it might not be of any help or of any use, and then you just need to make that decision based on your own particular circumstances. Okay,
so again, it would be taking into consideration perhaps whether or not you have assets you want to protect, and you use the example of the family home, right? So,
yeah, that's the biggest example, or kids, like I said, if you've got kids from a previous relationship.
And out of curiosity, I'm getting a little off track from the McCain divorce here, but if you're a wealthy individual in a common law relationship, you've decided not to get married, but you've been living with someone for, I believe it's 3 years is the length of time for a relationship to officially be common law, at least in Ontario. Would you recommend any sort of contract in that situation? I mean, does that change the dynamics of a split?
It very much does change the dynamics, because on a common law relationship and breakdown of a common law relationship, there is no automatic property sharing regime. So anything that is going to be divided on separation is going to be as a result of a trust claim, which has the potential to get very, very messy because it's a question of proof, and it's in question of entitlements and looking at all of the factual circumstances of different contributions that people have made, whether that's financial or non-financial. So it certainly does become a lot more onerous in order to have any type of division of property following a common law separation, because of the fact that it's not automatic, and those are not things that are legislated through the government.
Is it possible to sign any sort of pre-common law contract? Does that exist?
It does. It's called a cohabitation agreement.
Okay.
So similar type of situation where you're to either a marriage contract or if you're going to be signing it after, you would still be doing a separation agreement. In that, a cohabitation agreement, you're going to set out what you consider to be your property sharing regime on separation. So whether that's going to be specific provisions for saying I'm going to split the family home this percentage to this percentage, or that somebody would get a payment of a certain amount based on length of the relationship. So there are certain ways in which you can make provisions for that on separation of a common law relationship.
Interesting. Well, lots of good advice for people who are entering into marriages or common law relationships, whether or not they are wealthy celebrity heiresses. Thank you very much for joining us, Catherine.
All right. Thanks, Christine. Have a good day.
You too. That's Catherine Robinson. She's a family lawyer at Shulman Law Firm in Toronto, talking about the acrimonious McCain divorce that we are watching in the courts right now. Stay with us. Coming up next, Arlene Bynon from the Arlene Bynon Show will join us to talk about the news of the day and what's coming up on her show later this afternoon. You're listening to National Post Radio on Canada Talks, Sirius XM Channel 167. XM Channel 167.